Boom. Hey, folks, how's everyone doing? So, just as I'm about to start, I end up accidentally kicking my mic, and then I'm like, crap. I hope everyone's having a great day. And I see we've got to start off by rolling one of the new bumpers I made. So we'll go ahead and do that. That's this one. And that's because thank you, Sandy, for 20 gifted memberships. That's very generous. And thank you, Rainman, for 10 gifted memberships. All right. So I see not a lot of people here yet. And that's probably because I'm guessing Lawyer You Know is probably still streaming. So hopefully people trickle in. Today was kind of an eventful day. They had a bunch of things. And one of the most interesting ones is that we see that we learned some things about Turtleboy. Turtleboy is apparently going to be pleading the fifth, and that is that's kind of an interesting little detail. And I see somebody was noting what is it? Somebody was noting not great kitty has kidney issues. I'm sorry. That sucks. So is Natalie Lawyer Chick. Okay, so I've apparently picked the worst time to stream. I'm competing with everybody. Okay, so I hope everyone is I hope I'm not sort of dead last on the competition there, but it is what it is. So I should also probably set a goal, but first I'll tell you a little story about Potter behaving badly and Zora behaving cutely. So Potter was being an absolute little, like, how do I put this? So he was very much trying to steal dinner off the table. I did an unusual thing. Me and Mrs. Runkle had dinner, and yes, but Potter was very much trying to steal my dinner, like aggressively trying to steal my dinner. He was trying to take we ended up getting Greek food. He was trying to take this lamb chunk that came with it off of my plate. Like, his nose was coming up, and I'm like, no, buddy, you cannot have this. So, and then I was like, well, I guess it's our fault because he hasn't had dinner yet. And Mrs. Runkle goes, I just fed him. He literally just ate. And I was like, oh, he just wanted that. So anyway, what he did then is he went away, and we thought, oh, good dog. He's, gone. He's going to leave us alone while we're having dinner, and, excellent. So what did Potter do? Well, he snuck away, and then he got into a package of food and tore it apart. And so when I went downstairs, there was just this packaging everywhere with Potter sitting in the middle of it with this smug grin, like, I outsmarted you. And I was like, damn it. Meanwhile, Zora's fun moment was I was working from home, and often for lunch, I like to have a nap. And so I'm sitting there, and Mrs. Runkle was not home today. When Mrs. Runkle's home, Zora sticks with Mrs. Runkle. She just loves Mrs. Runkle more than anything, and I get it. So it's like, I agree with you, dog. She is the better person in this house. So I go to have a nap during my lunch, and because Mrs. Runkle's not home, Zora's like, I'm going to come join you. I'm going to come snuggle. And she curls up. She always does this and sort of curls up next to me. Except this time, it was the funniest thing, because as she goes to jump up into the bed, she rips off this loud fart. And so it was like, she runs up towards the bed and then just, I was like, seriously, dog? Seriously? So yeah, that was. And Beth says, can I get some prayers? Went to the doctor today and told I have a bad case of pneumonia. Well, we're all hoping for you, Beth. Here's hoping that all works out for the best. And yeah, that's sort of all we can do, I guess. But everybody in the chat, I think, is is cheering for you here. All right. So what we have today is motions hearings, and we've probably seen a whole bunch of the motions hearings so far. These are just sort of pre-trial things. Now, a lot of trials can be actually, I want to sort of emphasize that motions hearings can be really, really important, because I have had trials that I've won on motions hearings. So a lot of the time in Canada, we do this during the trial, but sometimes you'll do it in advance. And so, for example, I had a trial where a guy was accused of possessing a lot of drugs. Like, not a little bit of drugs, a lot of drugs. Now, here's the thing. Why was he accused of having a lot of drugs? Well, because he was driving a car and the drugs were in a bag on the passenger seat next to him, and he was alone in the car. So when you think about like what's going to happen at trial, you're thinking there's a whole bunch of drugs in the car. He's sitting there driving the car next to the drugs. It's going to be a tough sell to be like, that is not his drugs, right? But you might be wondering, what is there to argue in this case? Well, let me tell you how they found the drugs in this case. The way they found the drugs is that an officer saw this guy, thought he was suspicious, and directed his partner to grab the bag. And so his partner, who was by the passenger side door, and the guy had his windows open because, summer. The partner just reached in, grabbed the bag, and opened it, which you're not allowed to do, right? The officer has to have some reason to go through your shit. They can't just go through it because it's there. So we had an argument as to whether or not they would be allowed to use the drugs at trial. And in Canada, in the US, it would have been a very easy case, because in the US, it would have been, hey, they violated your client's rights by the search, and then they, and then the evidence is out. But in Canada, there's actually a second step, which is, okay, they violated his rights. Does the evidence get excluded? And so that was really the argument. And ultimately the court said, yeah, that has to be those drugs can't be used at trial. And that's the end of it. That's the end of the case. And the reason why that's the end of the case is because they're not going to be able to prove that he possessed the drugs if they can't mention the drugs, right? It's like, we're going to try proving that he has drug or without being able to mention that the drugs exist. So literally their case at that point would have been, we pulled a guy over and nothing happened, and we want you to believe that he was possessing drugs. It's like, nope, that's not going to be a win. So motions practice can be huge. It can affect what arguments you can make. As another example of a big issue that comes up in motions practice, think about, and I'm trying to remember her name now, the suitcase person. I'm bad with names. So the suitcase person, she had a pre-trial motion as to whether or not she's going to be able to argue self-defense. And she won that one. And it didn't help her. But Sarah Boone, yes, thank you, chat. But it didn't help her. But you can imagine a circumstance in which it could have helped her. Like, you can imagine a circumstance where she could have potentially had a genuine argument on self-defense. This wasn't that circumstance, but you can imagine one, right? And so you can have cases where there are examples of cases I can think of. There's one Canadian case, I can't remember the name of it, but basically the guy was denied the ability to make self-defense arguments. The court said, there is not enough here to make a self-defense argument, so you don't get to put this to a jury. And then on appeal, they said, yes, there's a self-defense argument that had to go to the jury. And so they retried the case. And once the jury on the retrial heard the self-defense argument, they said, this is self-defense. We have to acquit on that basis. So those kind of pretrial motions can be huge. I really don't want to. Sometimes it can feel like, this is sort of something that we just do and it's not really a big deal, but it can be a big deal. Also, I should set a goal. I'm going to tell you a story time of. So let's see. What's a good story time here? All right. We'll figure out something here. I'll put up a back pain story time, just because, that's something everyone will enjoy. Why is this not? Is it not like that word? Come on, goals. Everyone is sitting here watching me fight with the YouTube interface here. All right. Let me just try again. There we go. There's a goal. Back pain tales. All right. Now, while that goal is going, somebody says, to get personal, your hair is looking very silky tonight. Different conditioner. I know, because I've hair like yours, it's a bit of a pain. I will let you guys in on something maybe I shouldn't let you in on. The reason why my hair might be looking extra silky today is because I was in a hurry this morning and I didn't end up washing it. So, yeah. I wish I could say that that I had a better reason for that. So, yeah, it just is what it is. I didn't think it was too bad. So, just, yeah. All right. Give me a second here. I am just fighting with my computer. I'm like, hey, so I've got the screen up to share the screen to, for the things, and it doesn't want to actually share. Come on, StreamYard, share the screen. There we go. Okay, success. I had to do a thing there. All right. So, here we go. Now, the first thing they're going to be doing is talking about the motion to reconsider. And the motion to reconsider is about a couple of things. One, that they want a forensic copy of the Sallyport video. So that is the first thing. The second is an issue of the dog bite expert. They want to reconsider the dog bite expert. And basically you're saying this expert is awful. Do I ever put my hair in a ponytail when I need it to stay out of my, face? So I'll put it up in a ponytail for like when I'm doing sports or whatever. Okay.
Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr.
Can you guys hear this? The other, this is a good question. I want to get to this later. What do you think Sarah Boone's odds were if she said nothing to the police and didn't volunteer her phone? Nearly 100%. I could have won that case pretty easily if she didn't do that. Runkle does sports. Runkle does shooting sports when he can. Okay, so all right, let's keep going.
Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so
now you might be wondering who is Ms. George? Well, she is the local counsel. They've added her for pro hac vice purposes. So, yeah. All right, let's.
So I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that. All right, we'll start. First of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes.
All right, so let's talk about what they're asking for. Oh, yes, and she is the, oh, right. She's the lawyer, was the juror. That's what I've got. That's what I was missing. Where is... She was standing up a second.
What we all thought. Good morning, Ms. Reed. Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Right, that's the juror. Let's just.
Good morning, Mr. Leck.
Elizabeth Little, also on behalf.
Unetti for Karen Reed.
Good morning, Mr. Unity.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed.
that sounded.
Mr. Unity.
Good morning, Your Honor. Victoria George for Karen Reed.
So yeah, this is actually. I'm being told I'm quiet compared to the audio. Let's try to cut that down. So maybe I'll be louder by comparison. This is also one of the most unusual things that I have ever seen in the history of time. I've never actually heard of this happening before, like, ever, where on the mistrial, somebody who sat as a juror, she wasn't ultimately a juror, she was, she didn't deliberate, but somebody who sat as a juror has now joined the defense team. Do you know how bizarre that is? Like, I'm just trying to think of an analogy to compare this to, as to like just how strange this is. This is just like, it's unprecedented. I don't think it's ever happened before. Like, I would be surprised if it's ever happened in the history of time. The sort of it's just bizarre to me. And it really kind of says something, I think, when you've got the lawyer who was on the jury panel the last time, who stands up and is like, this is some bullshit that is happening. To me, this is, it's insane. Like, the only other thing I could think of is if you've got to pick a sports metaphor, it's like if the referee, decided halfway through a game that he was going to join one of the teams and like play for that team. It is, it's, I'm just at a loss for words because it is so weird. It is so strange that this would happen. And the thing is that normally when you get like a hung jury, a lot of hung juries come down to, like everybody wants to convict, and then one person is like, no, I am unwilling to convict. But this one was much more of a split. This one had more of a, and like, I also kind of like low key have just a, put it this way, I would say that this going on her resume makes her one of the most interesting lawyers ever out there. So, I mean, that's an interesting thing to have on, on that. And I am just stunned. Like, I would love to pick her brain on all of this because it is striking to me. And yeah, I would love to find out sort of what's going on in her head right now. So yeah.
Good morning, Ms. George. Good morning, Ms. Reed.
Yeah,
All right,
that's
so I
correct.
appreciate-
She was an alternate. She was, yeah. This is the other thing. How many lawyers does she have? Is somebody sponsoring them for her? Here's the fun thing. She, like, a ton of the lawyers sitting there are doing this for free or for discounted amounts, which means she is getting more pro bono value per second in that thing than I have ever made in my, like, if I look at like how much free lawyering she's getting there, it's probably like, $1,000 an hour easy worth of free lawyering. I think substantially more than that. So like, all of them are now working pro bono. So we're looking at five five lawyers working for free, and all five lawyers working for free are doing this, because they believe in it. Crikey. Here's the thing. Runkle's jealous of how pro bono he's not getting to be with that team. If I was barred in the United States, I would probably have sent them a thing saying, I will give up on covering this trial and go down there and I will just do grunt research, right? I will just do nothing but sit in a room and research case law, right? The thing is they've got lawyers in this room, several lawyers in this room who are really, really good. And, when you look at what it takes to be that good and what, like the lawyers who are that good can charge, can charge an arm and a leg. Now this is, lawyer Carl Steinbeck thinks that they should say when announcing themselves in trial, I am pro bono for Karen Reed. That actually would be fishing for a mistrial. I think that if they did that in front of a jury, they could get punished, because you can't tell the jury like that you're doing it for free. That is potentially biasing the jury. So I think that they would get hammered on that if they all stood up and were like, hi, Bob Alessi working pro bono for, like, no, that would get shot down so fast. All right.
Getting those lists on what we all thought. It's a copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
I just also want to note, like, if you're looking at this and you're going, I'm looking at this, and here's the thing. Like, everyone is like, so Karen Reed is innocent. And I think she's probably innocent, but I don't know for sure. I am not 100% certain of her innocence. I am certain that the prosecution thus far has failed to prove it beyond a reasonable doubt to me. And that is the standard, right? That she should be acquitted on that. That's the thing. Now, here's the other thing. Oh, really, Runkle? Thank you. He thought the jury would be biased. Karen must be loaded hiring all these lawyers. Carl is a lawyer. Different jurisdictions have different rules. But, like, if the prosecution did something let's imagine a prosecution close, right? Let's imagine that they lean over and Brennan says, and here she is with 5 high-priced lawyers. You object and you ask for a mistrial in a hot second over that, right? You just, you object in a hot second over that, because that is improperly biasing the jury there. So, yeah. All right. Now, the other sort of issue that you get on all of these things is that the jury may come to their own conclusions, but you generally can't address that. You generally can't, yeah. So, all right. The defense can do things the prosecutor can't. Yes, that's fair, but I don't think they can say how much they're getting paid. I don't think the judge would allow that. Certainly where I am, that would not be allowed at all. So,
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable.
So let's talk about what metadata is. Metadata is data about data. So, for example, let us say that you've got a file on your computer, right? You've got like a Word document. I've got a leave to appeal application that is ongoing, right? And so like if I pull up my leave to appeal file, which I'm not going to right now, but maybe we could go through that once it's in. Maybe that might be fun. But if I actually look at that file, not only does it have like the actual leave to appeal stuff in it, like the arguments I'm making to the Supreme Court saying, you guys should hear this particular matter. This is a matter of public importance. You guys should hear it. But there's also information on there that is things like, when was this file created? What time and day was this file created? What time and day was this file last edited, last modified? These kinds of things can be tremendously important in a case. Let's consider an example. Let's consider you've got a computer and it is located in a frat house. And because it's located in a frat house, there's a whole bunch of people who have potential access to this computer. Let's say it's located in sort of a central place in this frat house. So somebody goes and searches the computer and it's got bad files on it, right? Like it's got either bad pictures or it's got like somebody's detailed plan to use ninjas to kill the president. Something that you wouldn't want to be caught with. Well, whose fault is it, right? Who did this? And so you may need to like look at it and see like, what time was it created? What time was it accessed? What time was it modified? Because then you can see like, okay, well, maybe it was modified at this time. And that means that we can exclude all of these people who were in class, and have a great alibi because they were in a whole class full of people. And that class takes attendance and all of that, right? So, these kinds of things can be critical. I have won cases where people had stuff on their computer because it was clear that they hadn't done it on purpose because of the metadata. But metadata is also fragile. Metadata, you can imagine it kind of like a soap bubble. If you touch it, it breaks because once it tracks modification, if you modify that data by, say, moving it over, then you've now modified the metadata. So this is the issue. And in a case where everything hinges on was stuff tampered with, was stuff messed with, it is really important. And there will be arguments on whether or not this metadata was properly preserved.
And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that be properly imaged for our review.
You can hear her voice starting to break a little bit, and I think her voice is starting to break because she is really upset. Like, we're hearing this stuff for the first time, We already had a full trial on this, right? There was already an entire trial on this. And so all of this stuff should be old news, right? All of this stuff should have already come out. And now we're hearing that there's like the week before a trial, we're hearing that there's new information that they're getting. It is boggling to me. And frankly, this is the kind of thing that should have, they should have thrown this case out. It is a thing.
Okay, thank you, Mr. Bryan.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them
Every time Brennan gets up to talk, the first thing he does is throw shit at the defense. Like, come on, dude.
to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing, it's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that.
And so one of the things that I noticed when I was watching this earlier today, I was at work, just doing work and, sort of had this in my ears, but occasionally I'd glance up. And Ms. George has the most wonderful expressions. Ms. George's expressions are like, I'm just going to say, based on her expressions here, I feel like it's a good thing they have metal detectors at this courthouse, because that is the kind of facial expression that, left to its own devices, will pick up a knife and stab somebody. Like that whole face right there. She's just like, fuck.
So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So
Except that they said that they were welcome to come, but not to forensically image. So this is a whole thing.
the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in that request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Bryan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case, and it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case, but they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right.
Now, here's the thing. What they should have done is they should actually, this is taint team stuff in reverse, because the issue he's raising is like, listen, you can't have the entire police everything, because if you have the entire police everything, then you might get files that there are files that they cannot allow to leave for really good reasons. There are really good reasons not to give a complete image of everything. And some of this might be things like, hey, you might have the guy on the street by the name, going by the name of Weasel or whatever, and it turns out that Weasel is actually a rat, and Weasel is a police informant. Well, that's the kind of thing that they would keep secret. And if that somehow got released, that could be extremely damaging, because if Weasel is a police informant and people hear that, then Weasel probably gets stabbed in the, whatever. So, if, that's the kind of thing that makes sense not to have released. But this is precisely what taint teams are about. You could say, listen, we're going to release the full thing to a group of people who will then identify specific the specific files that can be released with certification that they are forensically sound. We're going to pare this down. But before that, he was saying that they wouldn't let them forensically, get a forensic copy of anything. So, yeah.
So the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to?
So the view is they're going to go to the crime scene. They're going to go to 34 Kenton, and they're going to go and have a look and see, and the thing is, it's important that they go to 34 Kenton, because then they can see, okay, here's what this place actually looks like. Here's, and coming over from Lawyer, good to see you. I hope that they are done over there, because, yeah. But, it's good. Or, sorry, 34 Fairview. I am tired. I'm sorry. 34 Fairview. So it's important that they see, how far is it? When they look at a picture, it's often really difficult to tell distance in a picture, right? Is the final place of, rest of the body, how far away is that from the little electrical box? How far away is from other things? So that's important. They're probably also going to have, they're probably also once again going to bring the vehicle out there. And so they're going to have the vehicle parked so that everybody can look at it. Now, the question is, you can't have Karen Reed riding with the jury, right? Because that makes no sense. That would not be appropriate. So this is what they're worrying about here. Now, you might go, why is this a thing? Well, because you got to worry about these things ahead of time. Because, yeah. All right. And I see we hit the goal. I'll tell you the story in a moment, and let's keep going here.
Two sides talk.
We haven't talked about the logistics. I'm happy to do that. I don't think that's a very lengthy conversation between Commonwealth.
Right, but we have to make arrangements. So that was something that I asked you to figure out. You
She's
say
like,
Ms.
I
Reed
asked
wants
you
to
to do
go
it,
on the
you
view.
didn't
She
do
can
it.
go on the view. How do you propose that's done?
The simplest way would be for her to, obviously, the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We're just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from.
That's actually a bad idea. You want somebody on that bus.
Jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle, because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
Now I'm so basically there's the reason why you want defense counsel on that bus is because then defense counsel can make sure that the jury's not doing anything stupid in the bus, right? Is the jury sitting there going, well, she's totally guilty? Because if they are, then you have to bounce that jury real hard. And you don't want it to be a situation where it's like the prosecution is on the bus and the defense isn't. So obviously they got to have somebody. So yeah, they worked it out pretty quickly here. It's pretty straightforward. It's just somebody's got to be on the bus. And so they're going to have one lawyer driver. I'm curious which lawyer they're going to have driving Karen Reed. Which lawyer is, I would say, drawing the short straw, except that's probably the more fun vehicle. So yeah.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see Counsel Tybar about this anyway?
Also, Court TV has once again been showing us the thing we all want to see, which is the ceiling fan. So, all right. I don't know why they're zooming in on the family. That I hate that. Court TV, stop it. Court TV, I love you guys, but you have an entire fan to focus on, right? Why are you zooming in on her family, right? Because this is a good question. How is having her vehicle there prejudicial to the defense? The jury could make determinations about that, and Brennan is like, they're gonna decide she's guilty. This is a tough why are we? You got an entire everything to focus on. You don't need to go up their noses.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor.
If you ever want to make friends with a judge, this is just a minor thing about defense practice and so forth. Judges like lawyers who can do this. Judges like lawyers who can do this kind of stuff where it's like, hey, Your Honor, I have taken this off of your list and, whatever. I had a case where we had there was an interview with the accused, and basically the problem is that the interview included things that were clearly admissible and things that were clearly inadmissible, and they were all together in the same statement. I can tell you that me and the prosecutor both gained in esteem with that particular judge when we went in and together we said, listen, we had a problem, which is this interview. So we are getting around this problem. We have a series of admissions that we wish to present to the court. And that's why the court isn't seeing the interview. It's just we're getting through this with admissions. And that was the Crown prosecutor being reasonable. That was me being reasonable. And the judge loves that. The judge is like, I like these two people. And so later, when you then have to fight something, the judge who knows you and who knows that you can do this reasonable stuff actually listens to you, right? So, because they're not assuming, they know that you're fighting it for a reason. Will we ever hear Lally again? No, right now, Lally is basically, Lally is Fortunato from the Cask of Amontillado. They are literally going to brick him up into a wall for this trial, it seems. We're not going to see anything from him.
We can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is? Okay.
I will do that.
All right, thank
Thank you,
you.
Your Honor.
Okay.
It's basically, we had a line we didn't want on the slide. Brennan's agreed. I'm going to give Brennan points for agreeing to remove some of that stuff. So, EDB suggested Lally read Karen's text. We'll get to that, but oh my God.
Okay. So, Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it.
Can I just say here that I think that this is actually an argument where Brennan might be right, and I'm going to explain why. Or at least I think he's less wrong, if that makes sense. Let's
Not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on
Oh, wait, this is the wrong one for him being somewhat right.
Dr. Russell saying she's the only qualified individual in the country, but rather this person.
Why are you relitigating Dr. Russell? You lost on Dr. Russell. Shut up about Dr. Russell. Because Dr. Russell is more qualified to exist than you are. Like, if I have to put my resume up against Dr. Russell's resume will eat my resume, and then
should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before.
what the fuck is a certified trainer? Like, there's certain jobs that you have to have a certification to do. One of the most obvious is lawyer, right? You can't walk into court and be like, I'm going to be a lawyer. Even though I'm a lawyer, I couldn't walk into this court and be like, I'm going to join in because I'm not a lawyer in that country. Doctor, right? Like, if you are a doctor, you know, that is a restricted profession. But like, anybody can train dogs. You can train a dog just by like telling the dog, like, so when there's a certification, sure, but it's not necessary.
And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes to, and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those. So those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there is, Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right, that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report.
The wambulance is here for Brennan.
Summary of his experience, because it would take a lot of time to go through it. For several years, he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs.
So bite and hold is like what they train cops dogs to do, and it's exactly what it sounds like. Bite, hold on. Why do they train cops dogs to do that? Well, because they're trying to facilitate arrest. And so, you know, you've got a guy who's running away and they loose the dog on them. The dog bites and holds and keeps the guy in one spot, right? They don't really want the dog to use tactics that a wild dog might use. because a wild dog might use tactics like, bite and rip the throat out. And that is considered detrimental to a police dog because you don't want bite and rip the throat out. You want bite and, and don't kill the guy, right? So, wolves and, dogs themselves, when you're running, they will do things like, they'll sort of attack at the back legs and try to rip out the muscles and so forth to keep something from running. Well, that's not what you want in a police dog. You want it to bite their arm and pull them down, right? So, yeah, it's basically the closest thing a police dog can do to arresting somebody. So, and the other thing is it depends on different breeds of dogs. They have different styles of attack. Dogs will often do sort of what you might call a harrying kind of attack. And what I mean by that is that they'll sort of bite and rip and then let go and bite and rip and let go. And that is great for, the wild if they're trying to tear something's legs apart so they can, eat it. But it's not so good for, for a police dog. Potter was not arresting the bag of food. Potter was being a jerk. I had to clean it up.
He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report.
He's got a shot at
in
Crosby.
addition, he cites two specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell. So Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters.
I also just want to say, I set up another goal for having a scotch too, but Alessi is really good at this kind of stuff, and I want to see him on cross. I haven't really seen him do a cross yet, but for this kind of I am going to explain and make my point, he is really good, and I am trying not to fanboy too hard over Alessi, but I really like Alessi's work. And I had somebody in chat at one point going if I was, if I was charged with something, I would want Runkle or Alessi. And I'm like, don't put me in the same category. You want Alessi. He is, I can say this without he is a better lawyer than I am. And I have no shame in saying that because it's true. So, yeah.
Given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a rebuttal, but as part of the defense's case in chief.
Why is this important? Well, because one of the reasons why Brennan said to kick out Lieutenant Wing was he said they don't get a rebuttal. So if they're trying to bring him in to rebut our rebuttal evidence, then he's inadmissible because you don't get one of those. So he's saying, no, we're calling him on our case in chief. We're absolutely doing that. And so that argument is complete horsepucky. Brennan made it up. And you can put it over with all of the things we're rejecting from Brennan, like in the same corner as Lally.
And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby.
By the way, folks, I know the audio is getting shit. That is not my fault. That's Court TV. It's their fault.
And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just going to say, I am not going to get into the basis for that. I just wanted to, because
I feel like Court TV might have hired Zora to do their cabling, and yeah, it gets better. It gets better.
Go ahead. Just move on.
yeah. So my request would be that a determination on
All right,
whether
we're
or not
going to
there's
jump
a
ahead a few moments because this is painful.
minimum wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right. So there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog.
This is the one where I actually think Brennan has an argument. And the thing is for the pattern recognition things, like I've said this before with, so this is basically tool mark analysis. And when we talk about tool mark analysis, we're talking about like, okay, let's say you've got a particular tool. We're talking like a screwdriver or something, not like a tool like Lolly. But, and then you apply that tool to a particular surface, it's going to leave marks. Now, the thing is my view is that the science is better with respect to exclusion of things to say that these two things don't match, that it's impossible for this specific screwdriver to match or to have created that specific groove than it is to say that this specific screwdriver did create that mark. That, I think, is much more suspect. And so Brennan's argument here is to say that they think that they can exclude Chloe. I'm like, I actually am okay with expert evidence on excluding that. So let's see the argument here.
I think that you can certainly talk about measurements that may have been.
Yeah, and this is the thing, is it's a lot harder to do that, I think, accurately when you're doing it with, meat. People are made of meat. We are all meat popsicles. And so meat bends, meat warps, meat all sorts of things.
Made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Okay, so what is that? What is that? That is basically a report that says that forensic odontology is a complete sack of garbage. And people have been convicted on the basis of forensic odontology. People have been convicted on the notion that, all right, so what is forensic odontology? Okay, so let's say you end up with, you find a dead person, and that dead person has been bitten for some reason. Like, I don't know why this particular killer got bitey, but they got bitey. And so that is, by the way, a thing that sometimes killers do for various reasons. One, sometimes people bite each other in the course of a fight, right? Like, let's imagine that somebody's coming after you and they want to stab you with this screwdriver, and they're gonna, like, they're about to, they're like, I'm gonna stab you in the face with the screwdriver. Okay, if you got a chance and you were fighting them, you might go, and bite them, right? Because you don't want to be stabbed with the screwdriver. That would suck. So people bite each other in fights. They're wrestling, whatever. They also sometimes bite each other because they're weird. So you might have like a SA allegation where there's a bite mark. You might even have something like, we found some body parts in a fridge, and somebody'd been nibbling on those, right? The whole like Hannibal Lecter thing. And so you'd be saying like, okay, yeah. I don't mean to judge if this is consensual bitey, but typically when we're talking about bite marks in the criminal context, it's non-consensual bitey. And whatever you want to do consensually is that's your call. I don't think I should have a say in that, frankly. But non-consensual bitey is not okay. Don't do that. Don't don't like go Mike Tyson on your partner unless they're into it. And even then, maybe don't do the full Tyson. Just keep it to like a 25% Mike Tyson. So anyway, they then have the task. Like, the idea that people had was, okay, we've got this bite mark on a, somebody's leg. Somebody was chewing on it. So here's a bite mark, on the bone. And so they were like, well, we have this suspect. Can we compare the bite marks on our dead person with our teeth that are in the live person? And so they would basically, like, that's the idea. And the thing is superficially, it is a persuasive idea, because you're like, well, all of us have teeth that are kind of unique. They're not all the same. And so you'd think, well, why can't we match teeth to teeth marks? And the thing is that ultimately when we studied it, and the thing, like, we actually sent people to jail over bite mark matches. That was like, people legitimately went to jail over this. And, that is a problem, because it turns out that we can't actually make that match. Now, let us consider, I can think of some situations where you might actively exclude somebody. So let's consider the most obvious exclusion category. The most obvious category where we could say that forensic odontology could exclude a person. Here goes. We found a series of teeth marks in this person, and the accused has no teeth. Not a single tooth in their skull. They just got gums. Well, then you might go, we can exclude this person on the basis that the person who left the bite marks had teeth and our witness got no teeth. right? Similarly, you could imagine potentially a scenario where somebody's teeth are so gnarly that they couldn't possibly have left a particular set of marks because somebody gets bitten and they've got nice, clean bite marks, with like this sort of arch of like the tooth marks and all of whatever. And then you look at your particular person and they've got like tusks. And you're like, okay, that's obviously not what did it, right? But the thing is for most places, most people, it makes sense. Now I do see people saying, what about dentures? Well, yeah, that may blow up your exclusion, but these kinds of things. But for the general principle of you can match a particular person to a particular set of teeth, the evidence and the science says, no, you can't. So stop it. And somebody's saying, so if you want to get away with it, you should have your teeth removed and burn off your fingerprints. I can say if you are looking at committing serious crimes, I would very much recommend that maybe you should, instead of committing those crimes, just have some teeth removed and some finger. Not in addition or not to help, just instead. So, yeah.
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar. So it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite.
I actually kind of agree with him here. So yeah.
Here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth.
Now, I mean, I have a notion here, which is that I don't know that I believe that Chloe is Chloe. Because, like, they've come back and they've said, oh, we found Chloe. And I'm like, bullshit. Bullshit. Like, I want to see the full chain of custody on Chloe. Because I'm like, is this actually Chloe or is this just some other dog? And the other question I have is I keep seeing people reporting, I don't know, like I am not an expert in dog faces, but I'm told that dogs' faces, like their teeth change over time. And so if you've got Chloe years later, is that the same mouth as Chloe the day of? Because if those things change, then it's not the same thing. So, you might say, okay, well, yeah, it doesn't match now, but would it have matched if they did the actual detecting at the time? Right? This is another solo cups problem. Like, this is another thing of like, hey, if you'd actually collected evidence at the time in order to investigate a case, like it's a freaking alleged murder of a police officer, like I have seen better investigative techniques on like liquor store robberies. This is everything on this is so freaking sloppy. I love this analogy that I just saw here. Like tread on a tire, it wears out. Yeah. That's the thing, is if you want to do tire tread matching, you want to match it to like close in time, the same day, a week later, not like 6 years later. Like that is no.
Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
I actually don't
It's an
hate
uphill
his
battle
argument.
for you, I'll tell you that. I'll hear from Mr. Wilson.
I don't hate his argument if they had better evidence. Like if they actually had Chloe from the day of and not, this like snowblower red solo cup bullshit that he's trying to pull here.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum,
he's like, even if you could match teeth, you can't match teeth with the dog shit that they have because they didn't do it right.
Inclusion, exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to?
So I just want to note, I would probably make the same ruling that you're going to see here, just on different reasons. So, yeah.
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection?
Now, somebody says, does she rule at all? She never rules, but it's pretty clear how she's going to rule, which is she's going to rule that he can't make that argument. Elf Wiggins from the top rope there, Breeden resorting to Air Bud law again. The Air Bud law is basically, I don't know a rule against it. There's no rule that dogs can't play basketball is what that's a refer. So he's saying, I don't know of a rule that says you can't testify about this. And it's like, well, that's not how it works. Where's the rule that says you can? Now, I would exclude this, not on the basis that I will specify specifically that that you couldn't ever exclude. I would say that they can't exclude in this case because we don't have the mold and the overlay, and we don't know that this is really Chloe, and we don't know that Chloe's mouth is exactly the same as when it was, when it was measured. So that's the basis on which I would exclude it. I actually kind of think there is some merit to Brennan's position. So Brennan's kind of arguing the point I often argue. It's just, I don't think this is the case for it.
To the substitute chemist. It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and defense.
So guys, let me go on a side rant about copyright. Because, somebody's saying, did I just hear someone say substitute chemist? I think that's a substitute DNA person. And basically it's just the supervisor or of one of the witnesses who was going to be an expert witness is sick. And, it's for blood alcohol. And so they are sick. And so they're just bringing in another person. It's not something really to fight about. So what I wanted to do is, that copyright prevents me from doing this because I would get a strike, but just a moment of Lally, where it sort of zooms in on Lally, and then it's like the Song of Silence. Hello, darkness, my old friend. As Lally sits there staring at his paper, doing nothing. The sound of silence. Yeah, I'm not allowed to do that. And we have 3 minutes left on the super chat goal. So, yeah. Okay. Carrying on
70,
here.
I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's going on?
We're happy to provide notice. We have not yet received that particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to.
So it's just everybody's like, yeah, we can provide stuff. All right. So at this point, we can move on to the sort of, we'll cover the next thing in just a second. So I am behind on super chats. We'll catch up with those. And I owe you guys a story. So Dina Kawaji, thank you for the 5 gifted memberships. Much appreciated. Pochi, glad you're covering this. Keep up the great work. Thank you. Gwendolyn SS, electric was off almost all day. Happy to be here. I'm glad you could be here, and you need power. That's important. Emily Ahrens, can't wait for your opinion on Hank's histrionics. We're going to get to that because I got some thoughts. Vez from Quebec, Brad steal bread from my hand, almost a finger too. I'm guessing Brad is the dog. And I love your you've got the thing there. I got to get the rest of those sent out. Sandy, are you slandering Rob's client? No, I'm accurately describing Rob's client. Chop Trial says, I left lawyer, to come here. Well, thank you. I appreciate it. Alley Cat says, story time. Joy W says, unfortunate pain tales. I hear you. Kimchi says, it's not that you didn't wash your hair. It's that you're piloting a new no poo regime. No, just because pain in the DuckTales. Woohoo. Phoenix Paw, you're first on my watch priority despite your dislike for super chats, so going to annoy you with some well-earned money. Keep up the good work. Thank you so much. Danielle Bossard, geez, how many lawyers does she have? Is somebody sponsoring them for her? They're all working for free, it sounds like. Joy W, could having 5 lawyers look bad to the jury? Defense has money. Jury might make conclusions about that. They might say, oh, well, the only reason, all of this is coming up is because they're they'll, they've got all of this. So yeah. Sometimes juries make decisions on bad bases. Sometimes juries have been known to be like, we're convicting because this person didn't look at us enough or looked at us too much. Like, that's the thing, is as the accused looking at the jury, not at all, they'll be like, that person's shifty, they're guilty. Or looking at them too much, they'll be like, that person was staring us down and we hate them. So, yeah. Winnie Bly, looking forward to the snark and wisdom. Thank you. Tough Cookie, thank you for 5 gifted memberships. Greg Brennan, looking his wounds after today. Rough one. Yep. Laura Christine, 7 out of 10. Hopefully that's not a rating. Kimchi, certified dog bite expert in Canton, Massachusetts, says, how does Brennan sleep with all the tiny violins that must always be playing around him? I think he goes to bed with the tiny violin sound. Light Queen, so glad to have Ruckle tonight. I needed to see a friend. Good to see you, Light Queen. Annabelle Feinstein, I've missed you the past few weeks. Passover is chaos. Fair. My dad is possibly converting. That's a whole thing. So Patty P, try zero gravity chair for your back pain. I should try that. Trust but verify. Thank you for the 10 gifted memberships. Much appreciated. Amy T, my EA Poe heart. Love the cask reference. Thanks. I love Poe. Wicked psyched. The prosecution is supposed to seek the truth, not a win. It is discouraging to see antics from a prosecution. Yep. I have had numerous cases over time where the prosecutor has said midway through the trial, they've said, like, I am no longer proceeding because I am not convinced that the person is guilty. And I have had one where they argued with the judge because the judge wanted to convict and the prosecutor was like, no, and wouldn't let them. The prosecutor was like, nope. I had one where I showed the prosecutor some evidence and I said, hey, I know I can't get this evidence in. It's inadmissible. I know I can't get this evidence in. It's just not, I just don't have a path to it. But it is actually something you should consider, even if I can't use it in court. And the prosecutor went, yep, I agree. You can't use that in court, but I am going to drop the charges because I am convinced based on this that this is a problem. So, yeah. Yep. Dubra79, Runkle, little off topic, but I saw a motion the Commonwealth made as to the CPD audit. I thought that wasn't allowed in. But if the Commonwealth brings it in, can the defense re-argue allowing Easter to testify? I don't think that they're planning on calling it. I think that they were just disclosing that it exists. So, yeah. So can there be any legal ramifications for Court TV or another network if they zoom in on Karen and a lip reader blasts their conversation all over Twitter? I don't know about repercussions like punishment, but I think that you would see the courts start issuing a lot more direction as to where those cameras get pointed. Just because how long after are you determining the state of the teeth of this accused person? That's an important question. Was it the same day? Was it years? Was it decades? Wicked Psyched asked Dr. Watley if he could prove the bite marks on a pencil. Prove George bought John Voight's LeBaron. I don't know what that's about. So, Kimchi says, my dog is demanding tummy rubs now. You rub that tummy. The Commonwealth knows Bev is biased and not very smart. A scary combination. I don't think she's actually dumb. Jordan Cox, thank you so much. Much appreciated. Just because, take the scotch. Thank you. Scotch. What should I make for the lady who gave me a bunch of alpaca fluff to make into yarn? A sweater, a scarf, a shawl? Whatever you think they'd like. I mean, a sweater sounds like a lot of work, but really nice. So just because says 10. David Craig says, Scotch, did we hit that goal? I'll have to check. Geraldine Friedrich, why wouldn't the defense say they have no proof it is even Chloe? Thanks for looking out for us nerds. I don't know. Apparently it's a Seinfeld read. I did not like Seinfeld. I didn't enjoy Seinfeld. So I don't get a lot of Seinfeld references because it was not a show I was ever a fan of. I know that's going to make a lot of people go, Runkle, we hate you. And that is fair. It's okay to hate me over that. But I did not like Seinfeld and still don't like Seinfeld. So I feel like I'm one of like very few people in the world who saw that show and went, no. But yeah. Now I thought I brought myself a little glass for scotch. I don't see it. So that's a problem. Do I have a little glass in here? Sometimes I've got a glass that I've set out and then I forgot about. I'm not going to do the full alcoholic thing of taking a bottle or pull from the bottle. That would just be bad. Do I have any improvisable containers? I think I do. Is there anything in this? We're going to use this. I'm like, I don't have a good scotch glass here. So what we're using is, I got this. I don't know where I got it, but it is actually a Forgotten Weapons flask. I don't have a solo cup. Now, this is actually really hard to eyeball because this thing has a lot of ounces in it and I don't want to get that smashed. So I am going to be drinking out of the flask. Somebody says, is that a flashlight? No, it is actually a flask. But yeah, so somebody says it looks like an adult toy. It's not an adult toy. What's his the guy who it's Jason Alexander, I think, who played George Costanza. I was not a fan of him in Seinfeld. I did not enjoy Seinfeld at all, but I did enjoy him in Duckman. And if you haven't seen Duckman, make sure you are like over 18. And but this clip is from Duckman.
Conspiracy.
Caution, Duckman is one of those shows that is highly offensive at times. So be advised about that. All right, let's jump back to things here.
See what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
Just
most.
for the court, the Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense, what you intend to put up?
Just a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay,
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
thank you.
So the concern here is basically just don't put anything in your opening statement, for the love of God, that will make us have a mistrial. Because they finally got a jury and it took them like a week and a half. And the last thing that Judge Bev, or really anybody, should want is a mistrial because one of the lawyers stood up and was like, I'm just trying to think of how you'd provoke a mistrial in your opening. I don't know. Brennan gets up and she's like, so Karen Reed's got 5 high-priced lawyers, and normally, they took some time off from defending, pedophiles and whatever else to be here. Like, that's the kind of thing that gets you a mistrial in 0 seconds. I can't see Brennan doing that, but, or just showing something that is clearly inadmissible, or something like that. It's like, okay, now we're in mistrial town. Great. Good job. So, yeah.
So I need the defense to look at this before the end of the hearing because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we've given them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
Yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you. So,
Thank
all
you.
right, so I'll just take a look at that.
You see everyone shaking their head as it's like, you know, I can bring you all back tomorrow or Friday. And they're all like, no, 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 please, God, no. So, yeah, like that just, it makes sense that they would just want to avoid the heck out of it. All right. So, yeah.
Okay, so that sort of also covers, I guess,
Wait,
the defendant's,
or in
Commonwealth's
small-
motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right, how are you going to find this person?
But we could have somebody plain clothes from the state police, or we could find somebody that's agreeable to the defense. But I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay,
So basically, the independent reader is just they want to bring out a person to read the text messages. Now, the defense has the opportunity to do the funniest thing because they're like, we could bring out somebody from the defense. Oh, and I forgot to tell you guys the story. I will tell you that, guys, the story in just a second here. I'm like, the defense could do the funniest thing and get like, you know, get like a voice actor. So here's the story of the back pain. You guys all know that I suffer from back pain and it's, you know, whatever else. And, you know, it's not a whole lot of fun, but whole bunch of you suggested that I should get like a TENS machine. So I got a TENS machine. And what I've discovered is that a TENS machine makes my back worse, not better. It just pisses my back off. It makes it angry and upset and makes my back want to stab me. So, yeah, that is, that is not, that's my adventure is like, I bought this thing and I'm trying to use it. And it's like, no, it just, it doesn't work. So I will have to think of something else. So yeah, I don't know. I also don't know what a good goal is to set. So
You may have a moment, Your Honor.
yes.
could Lolly be promoted to reader? He could be promoted to footstool. They're not going to use him as a reader because he's on the prosecution team. But so yeah. Does this stream have subs? Probably. Let's try. All right. Skip to when somebody's talking.
Time to, Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides. And that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
Matt?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts of the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think is creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
So the question then becomes, what voice will they use? And I mean, I saw a suggestion that they could just like what is it, pull up like the world's most that they could pull up like the world's most bland possible like, you know, thing. But I'm like, they could just get like you know, they could get some somebody who just reads evenly but run it through like a you know, run it through like a voice changer. So you know, just thinking here, what could they do? What's a good option here?
I mean, they could run this. I don't know what it sounds like. I don't know if you guys can hear this one. Maybe they could run something non-controversial.
I am told this might be a non-controversial voice that nobody would get upset about for any reason, that they could do that, right?
Or this one instead, just to really hit that, just to make sure everyone is sufficiently feeling that. See, it's just trying to fire up here.
Yeah, I mean, there's all sorts of options here. We've got, I don't know, this. All sorts of options. Okay.
So, we're just going to, you know, they could do it through an AI. They could, or through like a, you know, text reader. So, but, yeah. Somebody says definitely not that one. Okay. I used some of the voice changer stuff for when I was doing the last when I did one of the role-playing game things. I want to do that again. So, yeah.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, if he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody.
Ben Stein. Bueller. Yeah, that could work. But he's saying, why not bring back Cooper Guarino? Okay, that makes sense.
Come in, or other individuals come in to act as readers. I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be. And the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had.
Sigh. Sigh. We've got.
I don't know. How's this one? I can't hear it myself, so you'll have to tell me if that one is. Yeah. there's might be one that's
And worse, how's this? This is listed as the kawaii voice. I suspect it's awful.
Okay, enough of
Last
that.
time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between two independent people with motives that may or may not be consistent with the text messages.
Here's the problem. Text messages don't have tone. Have you ever gotten into a fight online because there's just no tone? And, you know, people understand the tone as very different things. So like one side is trying to say like, hey, I'm not mad. And the other side is like, you are super mad. And then you just end up with a whole big fight where it's like, you know, or you say, so, you know, these kind of misunderstandings where if you've got somebody reading text messages, they kind of are going to throw in inflection, right? They're going to throw in some sort of, you know, and they're going to apply their own meaning to it. I don't think that they can really help it. So, yeah. And I got to do this. Doing a little happy dance there. Hello, XCDA. Thank you for the 20 gifted memberships. Awesome. And let's keep going here.
As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. It's I understood it to be to take out all infliction and completely that.
They should just bring in Turtleboy to read them.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection.
How much will I follow the second trial? I'll be doing recaps. I'm not going to do live coverage. I'll do recaps afterwards. So
That would be inappropriate.
Thank you. All right. Defendant's motion for specific discovery, paper 638, Jimmy.
I haven't actually,
All right. Who's arguing it?
I haven't actually had a scotch in a few weeks, I think. It's actually quite nice. Now I got to remember to rinse this out, but that was quite pleasant. So, all right. I'm also working on trying to get some art, and I am struggling right now to try to get. I want to do more stuff for Roll of Law. I haven't done anything on Roll of Law in a while. And so I'm trying to get a game going on Roll of Law. What I'm trying to do is I'm trying to do something based around Cities Without Number is what I'm hoping to do, is a little Cities Without Number game. So Cities Without Number, if you're not familiar with it, it's kind of a cyberpunk kind of thing. And so I got it right here. So Cities Without Number. I've got as an idea. I'm just kind of reminded. I should have made this a super chat thing, but like a goal. I'll put as a goal here. I got to start another one. Runkle tells a story. So, but what I'm hoping to do is I'm hiring an artist to do like a series of images that'll end up being sort of a little comic strip to be a lead in. And I'm trying also to hire or to license a song to go with it. The problem is that music licensing is the worst. Actually, licensing music is freaking awful. So the first song I wanted to do was something from Johnny Hollow, but the problem is that Johnny Hollow, the band, is super psyched about the idea. They were like, yes, that is awesome. We'll take some money and we will do the thing. But the problem is that then the particular song I was looking at was Johnny Hollow has some of the rights. Some of the rights are from a producing company, and then some of the rights are with a person who did some editing on it. So the problem is that then I cannot possibly license this because I have to license it from 3 different groups of people, some of whom do not give a shit about anything. So that's the first problem. But I am now trying to pursue a second artist, and this artist I think owns all of the rights to their own stuff, and I'm very much trying to pursue them to try to get a licensing inquiry because their song would work really well for this, but I am trying to pursue them. So headaches and adventures. Can't you go through their distributor? No, it is really hard to license stuff. Just super difficult. So,
Yes, that's me, Judge. Good morning. Before
why don't I write it?
Mr.
Because I have no
Brennan and I
musical abilities.
conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say, as a preface, that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay.
So basically they want to know, hey, were there witnesses who didn't want to testify? Because that might suggest that they are not accurate. And yeah. Somebody says, ask John from Fumadane/Brumbasan. He makes mostly folktronic or dance music. It's got to fit with the theme. I don't want to use AI songs for this. Sometimes you just catch something that really works. And so the first one that really worked, I'm just trying to pull up the lyrics for it. It was, what is it? The sort of thing there had, so the song lyric I originally wanted to use started off with, you touched me with poison fingertips. You kissed me and sucked away my breath at you and left me for dead. Although that out of the version I wanted is edited out. You've given me 100,000 deaths. And then it goes to, I'm bigger now. I'm stronger now. My fingers curl their talons now. And my weeping eyes are burning now. My cloven feet are dancing now, which was going to sync up with sort of the thing and be the theme I wanted. That is Johnny Hollow's Boogeyman. Instead, the song, but because that's impossible, the song I'm looking at is Phil Dell. If I can get in touch with them and try to work out a license there, is The Wolf. And so the lyrics there that also work, what is it? You were sharp as a knife to get me. You were a wolf in the knife to fetch me back. The wishes I've made are too vicious to tell. Everyone knows I am going to hell. And if it's true, I'll go there with you. It's I'm doing terrible injustice to the song, but yeah, check it out. It's Phil Dell's The Wolf is the one I'm hoping to use there.
There's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Number 5.
So this is not the defense doing Airbud law. Rob, does Ian sound like Kermit singing to Miss Piggy to anyone else? Rob, you are too far away for me to come after you on that one. The thing is this is not him doing Airbud law, because he's like, this is not like, it doesn't say it specifically, but it's relevant. It's material. That's why they have to turn it over. So, yeah.
Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any
Also,
information of any...
Rob, would you play Star or Cities Without Number? Come on. You know you want to.
Witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth?
Now, I actually think that like these kinds of things make so much sense for like rewards, inducements, etc. Why would you provide that? Like, why would you disclose that? Well, obviously it's relevant. Let's consider the obvious situation of a witness who gets an inducement to testify. The jailhouse snitch. The jailhouse snitch, where you've got somebody who is looking at like a life sentence, and instead they're going to get, they're being told, oh, well, we'll just give you 2 years if you testify. That's an inducement. And would they have a reason to lie? You bet they would, right? You bet they would. And, that would be huge. What if you are looking at, do you think it affects a witness's credibility if they got paid $1 million versus if they got paid no money? Does that change their credibility? Of course it does. What if they express that they really don't want to testify? Well, that also might affect things. So, yeah.
Position.
Your Honor, that does not go to motive or credibility. It is not within Rule 14.
How would it not go to motive or credibility? Like, I find this to be so hard to, hard to reconcile with anything, right? So
Should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness. If they had any reluctance or concerns about testifying, I have been very broad in my agreement.
all right, let's just talk about this one. I had a case that hinged in part on a client's or on a witness's reluctance to testify. And you know what their reluctance to testify was about? They said, what if my evidence is wrong? Could I be punished for if I testify to something and it turns out that I'm wrong? Could they charge me with something over that? Like, that's obviously relevant if they're reluctant to testify because they were concerned that they might face perjury charges or some shit like that. That was obviously relevant, right? So, yeah.
Regarding discovery, anything that is Rule 14, exculpatory, even their specific requests, which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right, the ARCA witnesses, motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production.
Oh, you stand unsatisfied. Well, gee, that's freaking hard. Like, oh, what a freaking miracle. He's unsatisfied.
And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. And that is one viable option. My concern specifically is if they are subject to a voir dire the day before their test.
He really doesn't want the ARCA witnesses to go in. And here's the thing. From the prosecution's perspective, you should be fine with the ARCA witnesses, because if the ARCA witnesses are a problem for your case, this is the point where you should drop the case, because the ARCA witnesses are clearly not bullshitting, right? And it's clear that they are not people that were hired by the defense as like hired guns. And so if you have a problem with the ARCA witnesses' testimony, you should, like, this is a little like saying, I have a problem with that parachute that I'm about to use, right? You know, if ARCA is a problem for you, you should have an issue. And yeah, he's not afraid of the ARCA witnesses. He said it during all 20 of his motions to exclude them. He is so freaking disingenuous because he'll keep standing up and he'll keep saying, I'm not asking to exclude the ARCA witnesses. And the thing is if I was the judge here, I would eventually like start calling him on it. When he'd say, oh, I'm not trying to deny the defense the ARCA witnesses, I'd be like, great, motion denied then. Like, I welcome the ARCA witnesses. Okay, great. Then it sounds like your motion to exclude them is withdrawn. And he'd be like, no, it's not withdrawn. It's like, then don't tell me you don't have a problem with the ARCA witnesses, because you are telling me you have a problem with the ARCA witnesses. You know, stop talking if you don't have a problem with the ARCA witnesses. And
testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody.
I also just feel like when I'm listening to this, my thought was what year is this? Because he's like, we won't be able to send them home to get their messages. I'm like, the ARCA guys are not from like 1965. You don't have to put them on a plane to get their documents. If they're missing a document off of their servers, you know how they're going to get it? They're going to just print it out from wherever they are. They're going to get it in their so when he's like, how would we send them home? It's like, sir, have you heard of an invention called the internet and the invention of like a VPN into their local network? Like, they work for a company. If they're missing a document, they could call up and be like, hey, Bob, I know normally I use you in hypotheticals about murder, but today you're an assistant. And so can you send me go onto the computer and send me the files, these files. Yeah. Okay. You'll have them to me in 15 minutes. Awesome. Cool. Great. We're going to do that. It is. It's not like he's sitting there with a telegraph going boop, 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 please stop, send files, stop, files urgently needed, stop, send with next carrier pigeon, stop, end message, stop. Come on.
Custody and control. And then I asked the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that
we've received no new discovery other than the new discovery. Okay, thanks, Chips.
The notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify, that I'm looking for is for the court to have that voir dire.
Please don't let them comment on the opinion of my expert. My expert, he's not so good when somebody else is able to check his work.
And for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
It's got to be an iambic pentameter.
I want to go in reverse order briefly, if I could.
I feel like Jackson's beard keeps getting more and more epic, and I feel like he's going to walk in looking like a Sasquatch for trial day. Zombie Feed is saying, we now have a tenuous relationship with a former ally. Do you see a liberal government reinstating gun ownership? They've been promising to ban as many guns as they possibly can, so no.
Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice.
He's so upset about the deadlines that he has been completely unable to follow them. So, wah. This is kind of what that boils down to. Wah. So, yeah.
Completion, or certificate of completion, long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we.
While Jackson sleeps, his beard detaches itself and has been working on the case doing independent investigation.
What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once they get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but.
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points they were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13, another party says we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
She's like, I hate it when you guys fight.
Their response is that it's not in their custody control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. The discovery deadline has passed. And so I would like to talk about, or respond after Attorney Jackson is done, about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody control, well, it's certainly in the custody control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures.
This actually, that was an interesting moment because she was sighing at specifically at him. So that's interesting. That I thought was interesting. So yeah, I was interested in that little moment there. She doesn't normally do that.
I don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address.
Sometimes it can be a really good idea to just cut through the bullshit and just get to exactly what it's like, let's be honest, Your Honor, he's really just trying to prevent this evidence from coming in. Because as much as he says, I'm not afraid of ARCA, when he goes to sleep, he sees ARCA, and then he has to wake up and change the sheets. And not in a he enjoyed the dream kind of way.
It's number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we...
By the way, if you work with Brennan and if there's a Halloween party, I'm just saying you could dress up like the ARCA guys and it would be pretty effective.
have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case.
Can I hire ARCA to build me some like cannons? Because I would love to do that.
In furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with...
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rinschler talked about what he did, which was more on the biological side.
There was a difference between them.
And Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. And it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
Not to my knowledge.
He's like, I can't predict what they're going to say, but I don't think so. Like, you want me to, like, this is the problem, is that sometimes judges will ask you to, like, say, oh, can you guarantee this? And it's like, no, because that is a thing in the future from other people. So, yeah, I don't know why they're zooming in on Karen here.
Don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked.
You know who's not talking right now? Karen Reed.
Because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Like, she's not talking. We don't need the camera up her nostrils.
Right. Ms. Lynn I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
So can they testify as to what they did?
Yes, that is on.
Can they testify under what direction they did these things?
Well, they can certainly testify to what they did. Absolutely, that is on the table. Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
can I see counsel talk about this?
I don't know what that was about with Alessi, because he sort of grabs Jackson's arm and he's speaking to him kind of directly. So I'm like, is he just telling him, like, hey, man, you need to not screw this up? You know what I might do after this, chat? I'll just catch up on some super chats here, but also I'll tell you what I might do later. The world wonders. Nice to have a Runkle stream on my birthday, but yeah, teeth definitely move. I have gaps and tight spots I didn't even 5 years ago. It's true. Sigi and Mike, thank you for the YouTube membership. Ben Stein reading, did they bang? I'm here for it. Elijah, contribution to story time. By the way, we need a doggo cam as a calming reprieve from this trial. I don't have a doggo cam set up. Rainman YYC, I get the feeling that Rob's up for any game that will let him channel his inner murder hobo. You're not wrong. And thank you for the 10 gifted memberships. And I got to roll this. Sandy, thank you for the 20 gifted memberships. Much appreciated. Just because I just spent so much time going over the transcripts of the first trial for the first months he's assigned, proceeds to pretend he hasn't in the pleadings. Yeah, that's always interesting. Kate, maybe you have COVID, so this stream was a wonderful surprise. I'm sorry to hear you got COVID. Thanks for breaking this down for us, Runkle. Appreciate your insights as always. Thank you. Pamela Camel, Crash Daddy's now allowed to prep with the fence. Bang, bang. Fair. Rainman YC, got a stat block for an ARCA demon. I do not. Andrew Fidel, ARCA Cannon Fund. I think it might cost a little bit more than that in shipping, but Happy Annie says there's a ruling on this, and I bet Brennan is mad. I bet he is too. So one of the things I need to do in the near future, and I might do later, I have a flamethrower to test. Now, I can't actually test it yet with a flame throwing thing, but before I test it with like fire, like before you load it with gas and all of that stuff, they suggest you do a water test. And so later tonight, I might go out to a nearby park with a flamethrower full of water and spray that. So yeah. Regarding no doggo cam, Tim Pool was apparently pulling in 100,000 a month with his chicken camera. Okay, that's insane. Mark, I just got it on Amazon, so it's, it was like $40 on Amazon. So yeah. Super Soaker level 1000. I might be the person to win all of the water gun fights from now on. I might be like just the person who all of the water gun fights. So yeah.
We've been told
All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
that is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and that was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into effect.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving
Somebody in the back has a crutch, and I'm wondering who and why, although it's none of my business. So
information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There are 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information.
I see somebody asking, why is there so many sheriffs in the back? Or I'm guessing, or bailiffs, I'm not sure which they're called here, but I'm guessing that they are just here to watch. I just noticed that I had a couple of pieces of pizza for lunch, and I meant to give the dogs the crusts because the dogs love the crusts. I have not given the dogs the crusts yet. So our next goal effort is the doggos get the pizza crusts. So yes. Does your wife know about the flamethrower? Yes, it is very large. She definitely knows that. What time zone? I'm in mountain time. So, yep. Do they deserve the crust? Deserve ain't got nothing to do with it.
From Dr. Welcher, for instance, we knew that we wanted.
When you see this many, security folks, whatever they're called, whether they're sheriffs or bailiffs or whatever in a courtroom, it is one of two different things. Number one is they might have all been summoned because of a particular person. There's certain individuals who, when they show up at the courthouse, are followed around the court by like nine people. That's like the vexatious litigants. They get like followed. But you can also have like situations. There was one where, we had one where a guy was like an escape risk. And so they absolutely, like every time he had a court appearance, they had a ton of people there. So, that's kind of the first thing. But the other one is that sometimes they will just show up because they're curious, because they want to watch, right? Because sometimes they're people too. So, yeah, it's
at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when did you do
provided to them?
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just a quick look.
I have not yet got a response to Mr. Red Thumbprint, and it might be that my monkey letter did the job.
Additional discovery from the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to higher ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made
No, what you've been concerned about since the beginning of this case is that you might lose.
every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witness.
Oh, you're very entitled, sir. We all think you're entitled, just not in the way you think you're entitled.
This is provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report does not.
Yeah, you look like you're accepting that. Like this, of the stages of grief, this one feels like acceptance.
Have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement, it's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained.
Okay, let's talk about this. Let's talk about this because this makes me mad. This makes me a little bit pissed. So, we'll speed it up to 1.5 again. I just wanted to. So what he's saying is, how dare they make us make our opening statement before we know what they're going to say fully? And the thing is I get it. I get it, but I also don't. And the part where I don't get it is that literally nothing that ARCA says or doesn't say should in any way change your case, Brennan, because at this point, you think you know what happened. You think you know what went down, right? You think that she ran him over and whatever else. And so it shouldn't matter what the hell they say, because you shouldn't be changing your argument based on what they're going to say or not say or whatever. It should be you already know your case. Because it should be that you think you know the truth and that your job as the prosecutor is to get to the truth, and that not that you are trying to get to a conviction. Because what he's telling us here is, I am going to change what I think the truth is in order to get to a conviction. And like, this is not okay. I am not okay with this. I am mad with this. And yeah, I do not like this at all. Because if you are at the point where you are worried about what they have to say, pull the case. Drop the case if you don't, like, if you think that matters there. So, yeah. Also, I will agree with this one. I hope the O'Keefes are okay too. Kara didn't kill their son, but someone did, and nothing will take that pain. So I wish the very best for them. I do too. And I think it is tragic that the, that the O'Keefes are in this mess and, all of that. I don't bear them any ill will, and you guys shouldn't either. They're just, they're hurting. So, yeah.
Any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructions they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience.
They could have had any ARCA, like any accident reconstruction witness they want. Where are they going to find one that is better than the ARCA witnesses? And where are they going to find the money for another set of reconstructionists? Like, these ones are cheaper because they already did a whole bunch of the work. So, yeah.
Including the defense knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. I have more
violin.
And now we hear they waited until February 7th, 2025.
Mr. Brennan, I can keep violining all day. Like that. This thing's on batteries. It doesn't get tired. Like, oh, come on, dude. Just, climb down off that cross and
for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses. They have their report. That is all pursuant to discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it, I'll have no time.
What, you're gonna change your theory? Okay.
During trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has
If you knew it was going to happen, then why didn't you prepare for it?
to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I asked this court to do.
All right, I got a request to listen to Jackson's at 1 speed.
Your Honor, we
might take him up to 1.25.
What appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth,
how are we going to say what ARCA is going to do?
Disclosed
use them
in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions with rebuttal opinions and conclusions if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly
I'm going to pick it up to 1.25.
Nobody's at a disadvantage in this trial. We're simply trying to meet our obligations as we.
And I just got to. All right, you didn't want to hear me sneeze, but it would have muted him too. So
could, within the confines of the rules that were set up in no small part by the federal government, and now those strictures have largely been lifted, and we're moving forward as expeditiously as we possibly can.
rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us.
Oh, really? It's always an attempt to assign blame. My dude, you have never once stood up there without throwing shit at the defense. So,
late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
Thing is, at his best, Brennan is a very effective and, competent lawyer. But when he gets like this, where he gets like super emotional, I don't know. To me, it goes over like a kidney stone. I just really, really want it to stop. And
According to Mr. Alesi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing, and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aiden Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
Okay, so let's have a little talk about that. Before we get to Kearney, let's look at a couple of documents that have just dropped, because those are kind of relevant here. So, document number 1, and there's not a whole lot in this one, but I still want to present it to you just so that we can see it and so that we can talk about the little bits there are. Document number 1, we've got motion 4 to add. I don't like the motion 4 to add. It should just be motion to add Victoria B. George as additional local counsel for Pro Hoc Vice attorneys. Here's the thing that really stuck out to me at this one. Victoria B. George of the law firm Yannetti Criminal Defense Law Firm. Did you catch that? The juror who wasn't she wasn't a deliberating juror, but she was an alternate, who was there on the first trial, left, the jury duty, and then went to work for the defense counsel. I have never heard of this before in my entire life. Oh, of course she was hired afterwards. There's no way she would have been allowed on there. But I missed the whole thing about her working there. It is crazy to me. All of this is like when Rob and I get around to firing up Trials of the Century again, this is actually a pretty good claim for trials for what is a modern trial of the century, because I feel like this one is going to be talked about for a good long while because it's so crazy. It is so bizarre. But we actually do have a ruling on the motion from today. So let's see that too. All right. So, ruling on Commonwealth's motion to compel reciprocal discovery of ARCA witnesses. So it is ordered that by April 18th, the defendant is to produce to the Commonwealth any outstanding discovery listed under 1, 2, and 3 of the Commonwealth's motion, which is any bills, invoices, contracts, retainers, engagement letters, or payments that have been created for the defense of Karen Reed or provided to or from the Reed defense team from March 1st, 2024 to present. All emails, letters, or any written correspondence, including text messages at any time between any employee of ARCA and any member of the Reed defense team, including Karen Reed. All phone ledgers evidencing phone calls or text messages between any employee of ARCA and any member of the Reed defense team, including Karen Reed at any time. All right, so they got to produce that in the next couple of days. In addition, they must disclose any oral representation agreements or understanding regarding anticipated reimbursements or payments to or on behalf of ARCA between any member of ARCA and the defense team, including the defendant. And by April 21st, they must disclose any testing underway, requested, or contemplated. As to any testing underway, requested, or contemplated that is not completed, the date the testing will be completed, and the results of any testing. After receiving the above discovery, the Commonwealth may move for additional relief. What does this mean? Well, it means, like, the defense says they already have this. The Commonwealth is going to turn around and object again. They're going to say, we didn't get enough stuff. And they're going to be stuck with that for forever. So, yeah. Yeah, this is a good point, too. Lawyers are often bounced from defense teams because usually one side or the other doesn't want a lawyer on the jury, right? So typically, like, the professions that you can say that will generally get you kicked off a jury, if it's a criminal trial, cop is the number one. And in fact, often they will just bounce cop in general. But like cop or retired cop will often get you bounced. Lawyer will often get you bounced because people generally don't want lawyers. Now, here where I am actually disqualified from being on a jury. Even if I want to be on a jury, the law here says no, no deal. Yes, Andrew Fidel also points out, are you in a cop family? Is your brother a cop? Are your parents cops? Are you dating a cop? Have you ever dated a cop? You know, these kinds of things, they will often bounce you so hard because, you know, the defense doesn't want anybody who's got any relationship with a police officer. But lawyers, super often bounced. Court reporter, I don't know. I would decide court reporter on a case by case. Are you going to recap the trial at night? Yes, I will. That is the plan. So, yep. Drug and alcohol counselors often get bounced. Yeah, that makes sense to me too. Yep. All right. Embiggen.
No, Your Honor. There's also a motion
That
in
was a
limine
big
that was
mistake.
outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to...
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that.
So a third party's opinions are not admissible. It's a finding of the panel. Like, you know what the perfect example of a third party's opinions? This witness has been convicted of perjury. Well, that's a finding from like another third party, a different judge. So, but super relevant. So, yeah, I don't get it. Sodi's saying, how's your Supreme Court writing going? The initial brief is out the door. It has been sent.
That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
All right. So I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
We want to tell the jury that these officers suck all the things, right? They don't just suck. I'm not going to finish that sentence. There's no way for that to go well. They want to say that these are the worst cops that they've ever seen in their life. Like that these are shitty cops. So, yeah. Emily, that'll have to wait until another day. So, yeah. We're going to do this. We can look at Runkle v. Alberta another night. Maybe on a Monday? Maybe.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can.
She's like, excuse me? I wasn't sure if that was an I didn't hear or, yeah.
Try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know what I need is, I wasn't expecting this here today. So what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right. So we need to take a recess anyway, so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the...
You got a minute left on the pizza bones thing. I'm going to say the dogs are getting the pizza bones. It's just whether I do it on camera or not. I am blackmailing you on whether you see the dogs eat the pizza bones. So, yeah. You got a whole minute. We're 7 out of 10.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right. Were you as well,
I
Ms.
didn't
Little?
see that
Yes, you were able to see
statement.
the video and we have no objection.
But, yeah.
And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay. Thank you. All right. I'll hear you on this motion. Ms. Little, I'll hear
That's
your
fair.
response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
She's like, we've got some time for that one. All right. I am going to see if I can summon the doggos. So 1 second here. All right. Apparently YouTube is not properly crediting all of those. So I will have to credit you guys for the ones that weren't credited. All right. Let's call some pups here. Making sure my, Zora, Potter. I got pizza crusts. Now watch, they're not going to come. Puppies. Puppies. Yeah, come on. Come on. Come on. Okay, we got puppies. All right, everybody sits. Sit. You too, Potter. I see you not sitting. There you go. Good boy. Zora and Potter. Whoop. Here, let's make sure people can see you guys. There you go. Oh, such a good gentleman. Yes, good pup. They're such good puppies. Oh, I love them to bits. So they are, yeah. Okay, I need these back in my ears so I can hear. Yeah. Potter is very big, very gentle pup. I see. Wow, Potter is enormous. Potter is enormous. Potter is a big boy. We are not big fans of little tiny dogs, so we got Potter. So, yeah. All right, here we go.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay, can we address, is it something you need for your opening?
It's not.
Okay, all right, so yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out, all right?
Thank you.
Okay, so now is the only thing left the motion that Mr. Bradle's here for?
All right, and I got to stop right now to do this. JB, thank you for the 50 gifted memberships. That is awesome. Thank you so much. And what is it? I like real dogs, not sample size. Yep. All right, so we have next the Turtleboy. Was it gifts for the goal? Thank you so much. I actually talked to the YouTube people about can we set a goal for membership gifts? They don't have that set up yet, but they might do it. So here's hoping. So here's the issue. Turtleboy wants to be in court because Turtleboy is a journalist. And I know some people are like, oh, he's not a real journalist. Well, I will go on a rant for that because the rant that I have about that is that real journalist is a thing that we only just kind of made up. And we just kind of made it up in order to prevent people from actually doing journalism. Because what was a journalist originally? It was like anybody who happened to have access to a printing press or to a soapbox. In fact, in a lot of ways, what Turtleboy does is closer to the model of journalism that was in place when they talked about freedom of the press than the modern newspapers and so forth. Because, it used to be that you would have a lot of people who would get up there and they would say, hey, I am I'm just going to stand up on a soapbox and I'm going to give my, tell you what's happening in the world about politics and also maybe give my opinions on it. And I would do that with a little cup out in front of me. So when I have the super chat thing going on here, I am kind of the modern town crier. But Turtleboy started this case. Turtleboy was following this when no one else thought it was interesting. Turtleboy has done better reporting on this than a lot of people. So just the sheer fact that he's an independent doesn't mean shit. So, yeah, he's a journalist. And so he wants to come and report on this, but he can't if he's a witness, because if he's a witness, then they're going to kick him out of the courtroom, right? So that's what this is about, is can Turtleboy be in the court to report on this case? And yeah. The other thing is, let's talk a little bit about how much journalism has been tamed. What do I mean by tamed? Well, let's say the police beat the crap out of some guy. And you'll notice that all of the news reports about it are people reporting it exactly the same way. And they tend to use what's called the exonerative clause. It's not really a clause, but they will, what it'll be is and then the suspect was shot, and it's was shot, like who shot him? And they won't say that. It'll just be like, then the or something like the officers drew their firearms and the suspect was injured and taken to hospital. It's like, how was he injured? Suspect was killed on scene when police arrived. Was killed by who? Who killed him? Right? And the reason why that happens is because modern journalism is lazy. And modern journalism depends because if you want to investigate a case of like some guy dying, that is actually really, really difficult, right? And, you got to put a whole bunch of work in, but it's way easier to just go to the police press conference or look at their press release and then cut and paste. The problem is that if you piss off the cops, they stop inviting you to the press conference and you stop being able to get in. And so you lose that access. It's the same thing. Like when I do a review of something, like if I do a product review, the first thing I tell you is what I got for doing the review, right? I reviewed a flashlight at one point and I was like, hey, this flashlight is kind of merely okay. Merely okay. I don't recommend this, flashlight. But I told, one of the first things I said was, I did this review and I got a free flashlight. All of these kinds of things. But you'll get product reviewers where everything they review is awesome. And the reason why is because if you do reviews and where you say things suck, people stop sending you shit. So if you are a video game reviewer, you'll be like, why do you think that every video game is 10 out of 10? Well, because if you start giving bad reviews, then you don't get the advanced copies of things anymore. And then it makes it harder to do the reviews. So, it is, the media gets captured. The media gets owned. And once that happens, it becomes very difficult, to get unbiased coverage. And so where does it come from? Well, sometimes it comes from Turtleboy and people like him. And the thing is a lot of people think Turtleboy's a jerk, and that's fine. There's nothing wrong with that, because sometimes you kind of have to be if you really want to get to the truth without actually sort of following the party line. So yeah. Anyway, yeah. HuffPost does that all the time. It pisses me off every Friday. This item is considered a miracle product, and it's available on Amazing or Amazon, I'm guessing, for $40. Gets who gets a commission. Yep. I am still working on a video of where I am talking about a get home bag. And a get home bag is the idea of if stuff goes bad, if stuff at work or whatever else, do you have gear to help you get home? Right? Well, I think it's a good concept. When I started doing it, I didn't have an Amazon referral link. But the one thing I'm going to do is I'm going to say hey, listen, when you watch this, you're not going to see a single Amazon review link below. And the reason why is because I don't want to tell you things to buy because they're useful. I want to tell you things to buy because they're useful or good. I don't want to tell you things to buy because I get a cut. Because when you do that, then maybe it's not a good thing, right? Maybe I'm just doing it for a cut. Sometimes it's like, so here's a real basic example. My advice on the get home bag, like the first thing I talk about is, what do you use for a bag? And, one of the things I say is, my get home bag, the backpack I use for it is, I went to Goodwill. I think it was actually like a Salvation Army, but you get the idea. And I picked up a backpack and I paid $4 for it. And it looks like a basic B student backpack. And the reason why is because if there's some sort of chaos going on, the last thing you want to look like is a loot drop. You want to look like a student who nobody cares about. But, if I wanted to tell you guys, hey, look, there are these really awesome, like, tactical backpacks. There are some really great tactical backpacks. I could recommend $300 backpacks. And, those $300 backpacks, I would get like a 10% cut on each one. I could make $30 each time you're buying one of these things. But go to the Goodwill, buy the cheap bag. Like that's my recommendation, because it's a better recommendation. So anyway, the long and short of this rant is Turtleboy is absolutely a journalist because he does journalism. Anybody who decides to do journalism is a journalist. That's it. That's the thing, right? So, yeah, that's the criteria.
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So, Jim, you have that.
By the way, there are some things you should look for in a backpack. I'll talk a little bit about that, but yeah.
All right. I probably have it here too. I have one, Jim. Thanks. All right. I will hear you. Let me just ask, Commonwealth, you're moving to, sorry.
I don't like them, but there's not a lot of options for secondhand stores where I am. So, yeah.
You stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aiden Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is a strong likelihood that we would call Mr. Kearney.
Okay.
If the defense calls the defendant to the stand, I'm going to put money down that the defense is not calling the defendant to the stand. I mean, here's the thing. It's always risky to call the defendant to the stand. It is always risky. And the thing is I don't think Karen Reed would testify well. She does have a bit of RBF. So I wouldn't put her up on the stand. And I gotta roll this. AG says, big celebration for me tonight. I finished NCRA A to Z and start Project Steno next week. Congratulations. My money will get tight when school starts, so sharing the love now while I have it. I sent that email that I promised on the court reporting story. I will check that out. I've been a little bit buried, but thank you so much, AG. Thank you. All right, let's keep going here.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradle.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask if he were to call?
There he is. I didn't see him there before. Did he just show up? What is RBF? Resting bee face. Sometimes she does things with her face that are not ideal. It just is. And I gotta roll this. Rob, thank you so much. And I see you're saying, all right, y'all, or good night, folks. Good night, Rob. See you Friday, I hope. We'll see. And the thing is, I'm not judging her on the like RBF thing. It's not like a value judgment or anything else. It is just a thing of sometimes that's who your client is. I've had I had a client with an anxiety disorder and he's like, I want to testify. And I'm like, let's talk about that because you come off like you're lying when you tell me what you had for breakfast that day, right? You come off, you sound like you're lying even when you're just like telling the straight up truth. And so, and I've had clients who I had a guy who had like anger issues and it was a self-defense case. And I had a really good self-defense case without him testifying. And he's like, I want to tell my side of the story. And I'm like, you don't, sir. And he's like, why? I'm like, let's do a practice cross. And so I did a practice cross examination with the guy. I'm like, I'm going to pretend to be the Crown prosecutor. And he's like, okay. And I got him so pissed off, he threatened to fire me in the cross-examination practice. And I was like, let's dial this back here. Sir, you're this pissed off right now in our cross-examination practice. And I'm not even going hard. Like the prosecutor could go real hard on this. So, if you lose your temper on the stand, they're going to not think like the judge, because what is going to be a judge alone trial, is going to think you were the problem. He's going to think you started the fight. He's like, oh, I guess. Well, how confident are you that you're going to win? I'm like 80%, because that's about as good as it gets on a self-defense thing. And he was like, all right. Anyway, we got to the end of things and he's like, how are we doing? I'm like, if we don't win, I am appealing for free. And the judge, it was very obvious at that point. So
your client, would he take the fifth?
Yes, Judge. And I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so
they actually kind of like their interpretation of the witness interpretation statute is that like basically all of us are guilty of witness interpretation for breathing while thinking about the Karen Reed case, right? So yeah. Just it's a whole thing. And I see people talking about like the smile thing. Yeah.
just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
I'm sorry.
But that's okay. I don't want to hear about the witness intimidation statute other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see.
He's like, we anticipate it, we don't agree with it, but we also know we're going to lose this fight, so we're just saying we don't agree with it, but you can go ahead and rule against us, because we are not going to fight that particular wood chipper.
That would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
The membership gifts are random. There isn't really a way to direct it at somebody. YouTube has their own way to do it. So yeah, it's just a way to support the channel. I mean, people who get the gifts are happy, but really it's kind of a way to support me, I guess. So that's what it's for. So yep. Bradel I also like. He's got a really good style.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
I'm gonna give Brennan bet like some points here, because he's just like, yep, if he's asserting the fifth, that's it. I'm fucked. I'm not calling him as a witness if he's calling the fifth. So he can sit in court. I got no basis to kick him out. Props to Brennan for being reasonable on this point.
But as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
so basically, they're like, we want him up on the stand to assert his Fifth Amendment right. Okay.
7 minutes.
Sure. Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Yes, there is a setting to make sure that it's on. Brennan was big mad today. Yep, he was. Turtleboy is pretty pleased with this. So jumping ahead here.
You are unmuted.
Court is back in session. You may be seated.
All right. Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right. So you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
So that's basically a hearing to sort out which things are, or whether anything is something, because the Fifth Amendment isn't just a right to not testify, right? It's not just a right to be like, I don't want to be here. It's actually a right to not testify about things that are incriminating, right? So it's got to actually be connected to something that'll incriminate you. But yeah, I also hear you on the privilege versus right. It's kind of, I'm not super upset by it. So,
and I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right. Thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Kearney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to assert his fifth.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel. And all recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
So FTR goes to sealed, which means that you're not going to get the recording. Now, this is a good question. Runkle, what is the Canadian equivalent for the fifth? The Canadian equivalent for the fifth is that you've got a right not to testify or to be compelled to testify in your own defense. So what does that mean? Well, in Canada, Turtleboy would have to testify. 100% Turtleboy, if this was a Canadian thing, would have to get up on the stand. Why would he have to get up on the stand? Well, because our sort of Fifth Amendment equivalent works differently. So in Canada, you cannot compel the accused to testify at their trial. So what does that mean? It means Karen Reid cannot be made to testify if it was a Canadian trial. But if she chooses to testify, she has to answer every question. She can't then, say, well, I'm going to assert the fifth on that question. So once she gets up on the stand, everything is fair game, right? But let's go to the Turtleboy example here. If this was a Canadian trial, Turtleboy is like, listen, the evidence I give here would harm me in my other case, so I don't want to testify. In Canada, the way it works is it's actually an exclusionary rule. So if you've got, Turtleboy would have to come up on the stand and testify, and he'd have to tell the truth about literally everything. But that evidence could not be used against him at his trial. So as an example, let's say I am charged with a break and enter, right? And, I'm facing those charges. They think that I've got a burglary going on. And I was committing this burglary with Bob. Like, Bob was with me. We were breaking into somebody's house. We were stealing their jewelry. And then it turns out Bob gets charged with murder. Now, I know Bob didn't do it. And the reason why I know Bob didn't do it is because when the murder was supposed to have been happening, Bob was across town with me breaking into a house. And so I know Bob isn't the murderer because it's got to be somebody else. Bob was committing crime with me. And so they charge Bob with murder. And at Bob's trial, Bob subpoenas me. He says, Runkle, you have to testify. And I go, I don't want to. Well, I don't have that option. I couldn't go up and plead the fifth. I couldn't say I don't want to testify. Instead, I have to get up on the stand and I have to say, yeah, Bob didn't do it. We were breaking into places across town. That's what was going on. But at my trial, later on the break and enter, the burglary, they cannot mention that I had that I testified in that other trial and already admitted it. Like, I could have said every little detail about exactly how we did the break and enter together, and they cannot use that at my trial. So that is a whole lot of fun, right? Can I ask similar questions? Sure, but I'm not testifying at my trial. Why would I testify at my trial when I did it, right? Because if I got up on the stand to testify at the break and enter, the burglary trial, I'd be like, yeah, I broke into the place and that's no good. So the Canadian rule is different. And I have literally called people to testify about crimes they committed. And sometimes they like that. Sometimes they don't. So, yeah. What if your testimony gives them more evidence against you? Would it be admitted? Nope. Not if it's at somebody else's trial. So, can they use it to investigate? Maybe. That one gets a little more. Runkle, do you think of all these great stories on the spot? The burglary example? Yeah, that was here. All original metaphors. Listen, my brain is crazy. And I just turn it off. Like, I turn off the brakes on my brain and it comes up with weird stuff. Sometimes it'll be inspired by stuff. Sometimes it'll be an old joke or something. But a lot of the time it's just stuff going on in my head. So, yeah.
All right. So, Mr. Brennan, I've just had a colloquy with Mr. Kearney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege. And I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay.
He's like, I'm objecting to him being kept out, but we know we're losing. I'm just maintaining it in case I decide to appeal, which we're not. So.
All right, so we're all set until Tuesday, I believe. I'll get orders out. Oh, stipulations were just given to me. I have not had a chance to read them. All right, this looks like you all made some progress in a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay.
The jury is going to be happy that they will cut down on the amount of time otherwise. They might have stipulated to snow and high tops, which would have cut out like an entire 2 weeks of the prior trial.
Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy.
And it is something that we've done.
Right. Understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on this read, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, for the vote, please.
And back to everyone's favorite, the fan, the real hero of this story. Now, I feel like at the end of this, they should really, how do I put this? I feel like they should really take this fan down and auction it in order to support the courthouse, because I feel like they could probably like pay the court's budget by auctioning this fan off. Somebody would buy it. If I thought they'd go for it, I'd reach out to them and be like, so, for Extra Life, could we get the fan? Now, I kind of want to, I'm just looking at this. I'm like, would it be possible for me to figure out what brand of fan this is and to try to, auction that off for charity? I don't know. We'll have to see. So, yeah. Yeah, somebody says they could buy air conditioning with that money. Fair. Let's go through the super chats here. BL, now competent in ranged weapons and deranged weapons. I'm going to steal that line for a D&D game sometime. Geraldine Friedrich, does your wife know about the flamethrower? Yes, she does. 100%. David Craig, pizza bones. I'm now out of pizza bones. The dogs have eaten well. Forgotten Tupperware. Throw in a few scritches for us, please. They will get all the scritches. Potter got a few. Zora was being a little more aloof, but I can tell you, when I go to bed, Zora is going to 100%. Zora is going to come in and snuggle, because that is sort of how she rolls. So she is I love her to bits when she does that, because she's like the big old friendly teddy bear. Last night was date night, and so we'd originally planned to move date night because we thought that there was going to be a trial going on, maybe. So we had arranged to move date night, and then what is it? then we had it free. So we're like, bonus date night? Yep. So anyway, we were off, what is it? We were sort of watching shows and so forth. And Zora was like, I am going to climb up on you and snuggle. And it was like this giant teddy bear. And yeah, she was very, very cute. So love that pup. From my crust loving doggo. One doggo supporting another's crust habits. It's Oleg Mamatov in the park full of water. Doesn't that make a loaded gun? No, wouldn't be loaded because it's not ammunition. So nope. Is it the same as having a percussion cap in? All of this I'm going to have to add to my discussion of law when I get around to flamethrowers. I heard someone was charged for having one, percussion cap and a gun for having a loaded gun in a car. It can be in those circumstances. Brianna N., can the defense ask to reconsider ARCA testifying to cause of injury, since she later allowed the Commonwealth expert to testify to it, even though not a medical doctor? They did ask for that. I don't think they're getting it, but they asked for it. Gwynny Bly, for the puppers, thank you. Classic Overthinker, thank you for your ammo knowledge on regarding Richard Allen. Can you please do a video on junk tool mark science, comparing a fired cartridge to an unfired? I need to get around to that. AG, whenever you get to super chats, just checking to see if you got my email. I think so. I've been super busy. I corrected some things from the one I sent to Rob on the same topic. I will check it out. David Craig says, Dem Pizza Bones. Thank you. Forgotten Tupperware. For the Scotch Fund. Thank you. Kimchi. Pizza Bones. Thank you. Linda Santiago. Pizza Bones for Doggo. Awesome. Shay B says, gifts for the goal. Thank you, Shay B. Dylan, the Uprocker Schultz, Mitchell versus Jobs ended in favor of the plaintiff. I saw that. And people hate Carl Jobs for misrepresenting what the lawsuit was all about. Yeah, I keep debating whether I should cover that one. I think Hogue might cover that one, but yeah. Daffy 9 have been absent without a good excuse. Hi, Runkle. Hello, Daffy. Good to see you. Michigan Farm Boy. I saw him on Nick R's channel in May 2023. First, I'd heard of it. Discussion was pretty accurate, as I recall. Seems like a reporter, in my opinion. I think that's you're talking about Turtleboy or talking about me. I don't know. Hog Banana No, thank you for the gifted memberships, much appreciated. And Hog Banana No, little gift to the chat for my birthday tomorrow. Happy birthday, Hog Banana No. All right, we are at 11 o'clock my time. I will decide if I'm going to go play with a flamethrower outside, or if maybe I don't want to get tackled by the cops, but it might be fun. I just got to go see if I want to go spray some water at things and then figure things out from there. So, yeah, maybe I'll do that. Runkle, did you frame paintings? Not required, but just curious. I think it's in progress, but I don't think we've done it yet. They will get framed, but we haven't yet. So it's not an inside activity. No, this thing apparently sprays like 50 feet, so we're not doing that inside. Lori Vallow rested her defense with no witnesses or taking the stand. That doesn't surprise me. She's cooked. So, yep. Anyway, I will see you guys all soon, and have a good night. I will probably see you guys Friday, I'm guessing, if Rob does a stream. So, all right. Good night, everybody. See you when I see you.